Hello students, welcome to lecture number 6 of Indian Contract Act, which is a part of CA Foundation as well as Clat lecture series sponsored by Shri J in the Rank Zone. I am your mentor Shri Shekhar Galot. So today in this lecture we will discuss about some other important aspects of the contract and the process of entering into a contract. So we'll now begin with consideration. Consideration is an essential element of a valid contract without which no single promise will be enforceable. Okay, consideration is an essential element of a valid contract without which no single promise will be enforceable. So it means we cannot have a contract without a consideration. Because contract is a series of promises and counter promises. So when nothing becomes a promise until it is supported by a consideration. Therefore, we cannot have a contract without a consideration. So, any contract to come into picture, it must be supported by a consideration. Now, what is consideration? It is a term used in the sense of quid pro quo. Quid pro quo means something in return. It's a latent phrase which means quid pro quo. You must give me something in return. If I am giving you, for example, wheat, you must give me something in return. You go to the barter system, you give me rice, or you give me barley, or you give me some clothes, or you come to today's economic system, you give me money. Okay, that is something in return. Consideration means something in return, having a double aspect of a benefit to the promiser and a detriment to the promisee. It has a double aspect of a benefit to the promiser and a detriment to the promisee. It has to be really understood in the sense of some detriment as envisaged by the English law. In this unit, we shall try to understand the concept of consideration and also the legal requirements regarding consideration. Okay, it has a double aspect. Okay, it is a benefit to the promiser. Okay, wheat is going to the promiser and a detriment to the promisee. Okay, promisee is losing his wheat. Okay, someone is getting a wheat and other is losing a wheat. Okay, but he is getting money. So we are paying for the detriment. Consideration is the price agreed to be paid by the promisee for the obligation of the promiser. Okay, he it is a price paid by the promisee for the obligation of the promiser. Promiser says, A says I will construct a house for the B. B will have to pay. Okay, now in this case, consideration on the part of A is the construction of the house. Whatever knowledge he has for the construction of the house, whatever resources he will use, he will give a constructed house to the B. That is the consideration on part of A. Okay, but what is consideration on the part of B? He'll have to pay money. This money he will pay becomes a consideration for B. Excuse me. In this particular case, Misa versus Curie, a valuable consideration in the sense of law may consist either in some right. Consideration may be some right. Okay, it may be some right. Now let us take in this example. He says, I will construct a house for you. Okay, and B says, I'll give you third floor of that house. Now this is a part of right. Okay, some right. He has given a right that I'll give you third floor. This is also consideration. Interest. It's also an interest as well. Interest in the third floor. profit. Okay, or he says you construct a house for me, we will together sell it, and whatever amount we will receive by selling it, I'll pay you 25%, or benefit accruing to one party, or there may be a benefit like paying money directly, or forbearance, detriment, loss, or responsibility given, suffered, or undertaken by other party. Okay, it can either be a right or it can be a forbearance or detriment. Okay, now at this time when A is constructing a house for B, okay, he is also losing opportunity to construct the house for C. Now he cannot construct house for C. That is his forbearance, that I will not construct the house for C, rather I'll construct the house for B. Okay. Or say, now A goes to job, okay, for a job opportunity with the Reliance, and he says IBM is giving me 35 lakhs rupees. Reliance says you don't join IBM, we will give you 40 lakhs rupees. Okay, so this is for a forbearance on his part, that you do not join IBM, you join us, we'll pay you 40 lakh rupees. So this is a kind of some loss of responsibility suffered by A in this case. That is also a consideration. Section 2D defines consideration as follows. When at the desire of promisor, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or abstains from doing something, such an act or abstinence or promise is called a consideration. Okay, when at the desire of promisor. Okay, when A makes a promise to promisee, promisee is B. A says to B that you make construct a house for me and I will pay you something. Okay, so at the desire of promisor, because promisor wants promisee to construct the house. Okay, now promisee has done or abstained from doing. Okay, has done, he has now constructed the house, or abstained from doing, abstained from taking employment with the IBM, or does abstains from doing, or tomorrow he will abstain. Okay, or he promises that this is future, either he has already done. Okay, either promise he has already done something or abstained from something, or he will today do or abstain. Presently, he will do that thing or he'll abstain from doing that particular act, or promises to do, or to in the future to do so thing. Okay, like in future we have farm bills. This is a kind of a future contract. Okay, he promises to do. Now he promises to sell his crop to A. Okay, and he also abstains from selling it to any other. Okay, A contracts to a farmer B that in coming December B will sell all his crop to A. This is a future promise. Okay, so this is a future consideration. Analysis of the definition. Okay, now let us analyze what this definition says. Consideration is an act, doing something. Okay. Example: Ajay promises Bhuvan to guarantee payment of price of the goods which Bhuvan wanted to sell on 1 month credit to Chaitanya. Here, selling of goods on credit by Bhuvan to Chaitanya is consideration for A's promise. Okay, Ajay's promise. Okay. Now Ajay is promising Bhuvan that Bhuvan, you do one thing, you sell your goods to Chaitanya. Okay, and if Chaitanya is not able to pay the price, I guarantee that I will pay. Okay, now this is a contract between Ajay and Bhuvan. This contract is not between Bhuvan and Chaitanya. Okay, this is a contract between Ajay and Bhuvan, and Ajay says that I will make the payment for the goods you supply to Chaitanya. Okay, Chaitanya is only a beneficiary. Contract is between Ajay and Bhuvan. So on Bhuvan's part, the consideration is supplying of the articles or the goods to Chaitanya. On Ajay's part, the consideration is he will make the payment to Bhuvan. Consideration is abstinence, abstain from doing something. Consideration is abstinence. Abstinence means abstain from doing something, not doing something. Like we recently, in earlier classes, we discussed an example that A takes up. Okay, it is a kind of abstinence from doing something. A takes up a job with Reliance. Okay, now Reliance says because you'll take up job with us, you'll get to know a lot of our secrets. Okay, you'll get to know a lot of our technology involved. So you do one thing. Once you retire, you do not take any employment with my competitor. Competitor maybe IBM, because IBM is also in the similar field. So if you will join IBM, you will definitely divulge all the secrets, all the technologies, all the know-how. Okay, you learned at the Reliance. So at the cost of Reliance, ultimately IBM is going to be benefited tomorrow if you join IBM. So you do one thing, and definitely we cannot prohibit someone from working. So what they say, it's okay, once you retire from my Reliance, you do one thing for 3 years after retirement, because within 3 years they will bring the new technology. So the old technology is going to be of no use to the IBM. So they say for 3 years you do not take job with my competitor, that is IBM, and for that I will pay you, Reliance will pay you X amount, maybe any amount. Okay, this is now he will abstain from doing something. He'll abstain from doing what? He'll abstain from taking job with the IBM. Okay, another example could be here. Abhishek promises Bharti not to file a suit against him if Bharti, would pay Abhishek rupees 1 lakh. Here, abstinence on the part of Abhishek would constitute consideration against Bharti's payment of rupees 1 lakh in favor of Abhishek. Okay, so some civil action, some civil dispute happened between Abhishek and Bharti, and now Bharti says, I will file a complaint, I will file a case against you in the court. Abhishek says, you don't file a case, I'll pay you whatever your dispute is. Okay, so he will make the payment and Bharti will not file a case. Okay, or Bharti may have suffered some damage, like two cars collided. Okay, Abhishek damaged the Bharti's car in an accident, which is the responsibility of Abhishek. So Abhishek says, it's okay, the repair for your car will take 60,000 rupees, but I will pay you 1 lakh rupees. Okay, I'll repair your car as well as I'll pay you 40,000 rupees extra for not going and complaining against me in the court or filing a case against me in the court. And Bharti agrees. This is abstinence from doing something. Consideration must be at the desire of the promiser. Okay, because promiser, why promiser? Consideration must be at the desire of promiser. Why at the desire of promiser? Because it is always on the call of the promiser that the agreement comes into picture. Agreement is always initiated by a person known as promiser. When the promiser will initiate the contract, initiate the discussions, then only the agreement will come into picture. So it must be at the desire of promiser. Desire means okay, whatever promiser asked, it should be as per his wish. Whatever consideration is there, it should be at the wish of desire of the promiser. Now promiser wants B to construct his house, and B should construct the house only. He cannot say I'll construct a swimming pool in the house. No, he never asked for a swimming pool in the house. He just wanted a basic house. So whatever swimming pool he has constructed, now that is not on the desire of promiser. Okay. Okay, A contracts B for contesting his case number one at court. Suppose B is a lawyer and A is someone who is going through a court case in the court. So A tells B that you do one thing, you appear for me in the case number one at the court. Okay, so somehow what happened in the same day, case number two, in which case number two is also against the A. Case number two was also being heard in the court, in the same court. So B automatically himself appeared in the case number two as well for the A, thinking that I am entitled to do so. And now he seeks the payment from A. Now A says that consideration must be at the desire of the promiser. The consideration should have come at my desire, and I asked you, and my desire was only for you to appear in case number one. Now you have appeared in case number two automatically, but I am not bound by that agreement. Now you have done that, I'll pay you some fees. Definitely, I have to pay you some money. But you cannot say that you pay me the same fees which you paid me for contract case number one. No, I'll pay you something, whatever I feel good now, because you have done it automatically yourself without my permission. So there is no contract. But yes, because you have done something, I'll pay you, but not the fees for court number one, case number one. I'll pay you some other fees. Consideration must be offered by the promisee or the third party at the desire or request of the promiser. Okay. Consideration must be offered by promisee or third party. Third party may be that some other person doing it for the promisee. Now A contacts B for contesting his case. Okay. Okay. B, instead of going himself, he sends his legal team to defend A, and the team is successful. Okay. Now here the contract is performed by the legal team. Okay, not by B himself. Okay. So that is also okay, because ultimately what is relevant to the A? For A, it is relevant that he should succeed in the case. So consideration must be offered by the promisee or the third party at the desire or request of the promiser or third party. Here legal team is third party. This implies return element of consideration. Contract of marriage in consideration of promise of settlement is enforceable. Okay, he says that he will construct a house for B if B is willing to marry A's daughter, and this is a valid contract. Okay, okay, this is a valid contract. If the daughter is willing to marry and if the B is also willing to marry, then this contract can be enforced. Okay, However, if tomorrow B says I will not marry, or A's daughter says I will not marry B, then A can take compensation from B, but he cannot compel him to marry. Okay, there can be no compulsion for marriage. Okay, so now he is contracted. A says, you marry my daughter and I'll construct a house for B. B says, okay, upon the construction of the house, I will marry your daughter. Tomorrow, B says, no, I do not wish to marry your daughter. Okay, then in that case, Indian law cannot compel anyone to marry someone without his choice. Okay, so now law cannot compel B to marry A's daughter if he does not wish to do so. But definitely, because A has constructed the house for B and B has now committed a breach of the contract. Okay, he has committed a breach of the contract. He has broken the covenant of the contract. So now he must pay compensation to A. Okay, he must pay money to A for what? Because he has definitely constructed a house for the B. If he does not wish to marry A's daughter, if B is willing to marry A's daughter, he will not have to pay anything for this construction. If he is not willing to marry A's daughter, then he'll have to pay money. An act done at the desire of a third party is not a consideration. Okay, but an act done at the desire of third party is not a consideration, because consideration is at the desire of promiser, because promiser wants you to do so. Okay, let us read it now. In Durga Prasad versus Baldev, D. A defendant promised to pay to P a certain commission on articles which would be sold through their agency in the market. Market was constructed by P at the desire of C and not at the desire of D. D was not bound to pay as it was without consideration and hence void. Okay. D says to P that I will pay commission. P was doing one thing, P was constructing some market.
It's 8 o'clock.
Okay, now let us understand this case law. In this case, what happened? This P tells to D that tomorrow if you construct a shopping mall, okay, if you construct a shopping mall here, D tells P, if you construct a shopping mall here, I'll pay you commission on whatever sale I do. Suppose I make a sale of 100 rupees. On 100 rupees sale, D would pay 5 rupees to P. Okay, D would pay 5 rupees to P. But later, what happened? P did not say anything to D at that particular time. But what happened later on? P was commissioned by collector of the area. Okay, he was instructed by the government that you do one thing, you construct a shopping mall there. Now P constructed a shopping mall there. Okay, now when D went on to make the sale, P came to collect the commission. Now D refused to pay the commission. This case went to the court. Court said that there was no consideration on the part of P. In the contract, there has to be consideration on the part of both the parties. On D's behalf, consideration was that I will pay you 5 rupees and 100 rupees. And P should have constructed the shopping mall. But P, though constructed the shopping mall, but he did not construct the shopping mall because D asked him to do so. He constructed a shopping mall because of the collector. Okay, so there is a contract between P and the collector. There is no contract between P and D. When P has not done anything for the D, D is not bound to make the payment to P. Okay, because the contract is being performed at the instance of third party. Third party is collector. They both were the original parties, but P did not construct it for D. He constructed it only for the instance of collector, instance of third party. So when something is done for the third party, D or the promisor is not bound by the contract because consideration must be at the desire of promisor. It should not be at the desire of third party. It may happen that third party also desired something and promisor also desired that same thing, but because the other party has acted on the instance of third party, now promisor is not bound. R saves S goods from fire without being asked to do so. R cannot demand any reward for his services as the act is being done voluntary. Okay, for voluntary services, he cannot demand some compensation. Okay, voluntary acts. Okay, definitely, society and the people do reward people for their heroic voluntary acts. But tomorrow, if someone says that I shall not pay anything for the heroic act done by you, then other party cannot compel. In this case, R saved S's goods from fire. Okay, but S had not asked R to do so. So now R says, because I voluntarily put my life on danger and I saved your goods from fire, now you must pay me a reward. S says, I shall not pay you anything because you did not do that upon my desire. You did that voluntarily. Okay, so now S is not bound to pay anything. Consideration may move from promisee or any other person. Consideration may move from promisee or any other person. Okay, promisee means A. That means A promiser tells B, which is a promisee, to construct house for A. B asks his subcontractor. Now B has a lot of contractors at his disposal. He asks some of his contractor to construct the house for A. Okay, so the house has been constructed. He wanted his house to be constructed. His house has been constructed as per plan submitted by him. So he cannot say no. You should have yourself come and put on the laid down the bricks and mortar everything. No, definitely he cannot construct the house alone. He'll need some agency. So he asked his subcontractor, you perform this contract. Okay, so subcontractor is a third party. Okay, so consideration has moved from the third party and that's a valid contract. Or suppose A along with his father. Now in this case, A, who is a minor, well, let's not say minor. He is just 20 years old. He wants to buy a bicycle or a scooty or a motorcycle from the seller. He says, you sell me a motorcycle, I'll pay you money. Now he paid money from his father's account. Okay. So father is a third party to the seller. For seller, the direct party is A, but he has received the payment from father's account, so it is a valid contract. He cannot say no, you must pay the money, only you only, I cannot take money from your father. He cannot say that. So in India, consideration may proceed from the promisee or any other person who is not a party to the contract. The definition of consideration, as given in section 2D, makes that proposition clear. According to the definition, when at the desire of promiser, the promisee or another person does something, such an act in consideration. In other words, there can be a stranger to the consideration but not stranger to contract. An old lady made a gift of her property to her daughter with a direction to pay a certain sum of money to the maternal uncle by way of annuity. Annuity means annual payments. On the same day, the daughter executed a writing in favor of the brother agreeing to pay annuity. The daughter did not, however, pay the annuity and the uncle sued to recover it. It was held that there was sufficient consideration for the uncle to recover the money from the daughter. Okay. Now, old lady gifted the property to her daughter and said that I am gifting my property to you, but you must pay certain annual payment to my brother, to your uncle. She agreed by the deed, and later on she refused to pay the consideration to. She refused to pay the money to uncle. Now she went to the court, and after the death of the old lady, she says that there was a contract between the old lady and me. Uncle is not part of that contract. Okay, so I will not pay anything to the uncle. But court said that because it was agreed in the contract that you should pay it. Okay, and this was a part of the contract was dependent on this particular condition that you will pay, make the payment to uncle. So now uncle can recover the money from you. Executed and executory consideration. A consideration which consists in the performance of an act is said to be executed. Okay, a consideration which consists in performance of an act is called executed. You pay me sugar, I'll pay you money. He pays sugar, the consideration is executed hand to hand. When it consists in a promise, it is said to be executed. When it consists in a promise that I promise to pay you sugar on some other date, okay, it is executory. When consideration is performed, then and there only it is a executed perform consideration. When the consideration is going to be performed in the future date, that I will purchase all your crops in the future. Okay, that is called an executory consideration because it is going to happen in the future. I am making the payment today, but he will supply me grains or the crops only on the future date, that is coming December. So that means it is an executory. Executory means something which is yet to be executed, yet to be performed. Executed means already performed. Example: A pays 5,000 to B and B promises to deliver to him a certain quantity of wheat within a month. Okay, in this case, A pays the amount whereas B merely makes a promise. Therefore, the consideration paid by A is executed, whereas the consideration promised by B is executory. Okay, so this is the case of where one consideration is executed, other consideration is executory in nature. Consideration may be past, present, or future. Consideration may be past, present, or future. The words has done or abstained from doing. Okay, that means has done means past. because he has already done it. Are a recognition of doctrine of past consideration. In order to support a promise, a past consideration must move by a previous request. Okay, there must have been a request made by the promiser. Then only it should be considered a proper consideration. It is a general principle that consideration is given and accepted in exchange of promise. The consideration, if past, may be the motive but cannot be the real consideration of a subsequent promise. But in the event of the services being rendered in the past at the request or desire of promiser, the subsequent promise is regarded as an admission that the past consideration was not gratuitous. Gratuitous means free, voluntary, free. Okay. Now it says when you have done something in the past, it will act as a consideration. Okay. Now A asks B to provide money to A. He says to B that you pay money to me. I want to take coaching for exam. Okay. When I will get a job, whenever I'll get a job because of that coaching, I will pay you your money back along with some interest, suppose 4%, 5% interest upon your payment. Now it took A 4 years to get that job. Okay. So now B has already done something. B has already performed his part of consideration. Okay, in the past. Okay. When he did so only at the instance of A. Okay, that means now contract is complete and he must pay it. Okay, now suppose A did not ask it but B says you study, I will pay, and nothing of the sort was said by the A. Nothing in the return was promised by the A. Neither B asked for anything promised for anything in return from the A. Now A has taken up a job after 4 years. Now B says you pay my money back along with the interest as well. So now A can refuse the contract. A can say I had no contract with you because your services were gratuitous. You yourself offered the help. I never asked the help from you. Okay. So your service was gratuitous, voluntary, it was free. A performed some services to B at his desire. After a week, B promises to compensate A for the work done by him. It is said to be present consideration and A can sue B for recovering the promised money. Now A can sue B for recovering money because it is a present consideration. Consideration need not to be adequate. Consideration need not to be of any particular value. Okay, it does not have to be adequate. Okay, whatever may be the price, whatever may be the consideration. Okay, No one in the law is permitted to go into the adequacy, that whether it was adequate or not. Okay, it has to be there. Consideration has to be there. It can be even 1 rupee, 2 rupee, 10 rupee, 100 rupee, anything, but it has to be there. The consideration must be valuable. It must have some value in the law. Okay, it cannot be illusory, it cannot be just imaginative, that I will pay you back by giving you a plot on the moon. That is not a valid consideration, because no one has a plot on the moon right now. Okay, but it must have some value. So adequacy is not the concern of the law. I may sell a car which I purchased for 1 crore rupee today to someone for 10 lakhs rupees. Within one day, my car is losing 90 lakhs rupees of its value. But since I'm getting something in return, and what am I getting in return? I'm getting 10 lakh. Other parties paying me 10 lakhs rupees. Courts or no one can decide for how much I am willing to sell my car. I can sell my car for 5 crore. If the other party is willing, I can sell my car for 2 lakhs rupees as well. That is between me and the other party. No other person should have any concern with the adequacy of the consideration. But an exception, if it is shockingly less and the other party alleges that his consent was not free, then this inadequate consideration can be taken as an evidence in support of the allegation. Though there is nothing wrong on the contract in which inadequate consideration has been paid. Suppose I am paying 2 lakhs rupees for a car which is costing 1 crore rupees yesterday only. Okay, so the consideration is inadequate. Definitely, it's inadequate, but the contract is valid. But tomorrow, the other party wishes to say that my consent was taken by undue influence or fraud or coercion or some other instances were there, and my consent was not free. You remember we discussed that consent has to be free consent, it should not be vitiated by fraud or misrepresentation. Now, the party which sold the car valuing 1 crore to a for 2 lakhs rupees. The party alleges that though there is a contract, but contract is not entered with free will. The contract was not entered with free consent. So court can very well take into consideration that this is shockingly less. Okay, the consideration, the price for 1 crore rupees car, the 2 lakh rupees for 1 crore rupees car is shockingly less. Court may take it as an evidence that yes, indeed there was a misrepresentation or coercion, because in normal times nobody would sell a car which is costing 1 crore rupees today to someone in 2 lakhs rupees tomorrow. Okay, one car will not lose 98 lakh rupees of its value within a day. So nobody will sell it in such a casual manner, and definitely when it has happened, that means other party has not acted in the free consent, has not acted with the free consent. X promises to sell a house worth rupees 6 lakhs for 1 lakh only. The adequacy of the price in itself shall not render the transaction void unless the party pleads that transaction takes place under coercion, under influence, or fraud. Okay. Performance of what one is legally bound to perform. Consideration must not Consideration must not be performance of the existing duty. The performance of an act by a person who is legally bound to perform the same cannot be consideration of contract. Hence, a promise to pay money to witness is void, for it is without consideration. Hence, such a contract is void for want of consideration. Similarly, an agreement by a client to pay to his counsel after the latter has been engaged. A certain sum over and above the fee in the event of success of the case would be void, since it is without consideration. But where a person promises to do more than he is legally bound to do, such a promise, provided is not opposed to public policy, is a good consideration. It should not be vague or uncertain. Now, this term says when someone is legally bound to do something, no one can enter into it cannot be consideration, because he is legally bound to do that thing. Okay, A as a police officer, he is legally bound to protect the citizen within his territory. So now what happened? B says there is one miscreant, there is one hooligan, or there's a gangster. He now threatens my life. If I do not pay him back, you protect me from him. A says, okay, I will protect you from that particular person, but you'll have to make some payment to me. Later on, B refuses to pay A. Now A cannot go to the court. Why? Because A is legally bound to do. A is legally bound to protect the B. A cannot take money for something which he is legally bound to do. Okay, for this there is no contract. This is not a consideration. Okay, but if this person is doing something extra, then he can pay him. Okay, now A. Okay, now what happened? A, now in this case again, A is a police officer. He now says, I will protect you from the hooligan. So now he is posted outside B's house. So meanwhile, he also gives tuition to B's son. Now A must be paid for the tuition fees because this is not his legal obligation. He is doing something extra. So when you are doing something extra and you are not legally bound to do that thing, then that can be a valid contract. Now this is a valid contract. Now this police officer must be paid for the tuition fees. Okay, he cannot say that because you were posted, it was your duty. His duty is only to protect. His duty is not to give tuition. Consideration must be real and not illusory. Illusory means imaginary. Consideration cannot be imaginary. Imaginary consideration is like bring down the stars. Okay. Consideration must be real and must not be illusory. It must be something to which the law attaches some value. If it is legally or physically impossible, it is not considered a valid consideration because bring down the stars, I'll discover the magic, or I'll walk on water, etc. These are not valid considerations. These are not real. These are only illusory, imaginary. A man promises to discover treasure by magic. This transaction can be said to be void as it is illusory. Okay, because this is illusory. This is imaginary only. Nothing is happening in reality. So this is not a valid consideration. Registers a plot in somebody's name on moon. Okay, these are not valid considerations. These are illusory. Consideration must not be unlawful, immoral, or opposed to public policy. Consideration should be valid, should be legal as well. It should not be unlawful, immoral, or opposed to public policy. Only presence of consideration is not sufficient. It must be lawful. Okay, anything which is immoral or opposed to public policy also cannot be valued as consideration. A agrees with B to sell car for 2 lakhs to B. Here A is under an obligation to give car to B and B has the right to receive the car on payment of 2 lakhs, and also B is under an obligation to pay 2 lakh to A and A has the right to receive 2 lakhs. Okay, 2 lakh is a valid consideration. Now in this case A says you Now he says you commit robbery for me and I'll pay you 2 lakhs rupees. Okay. Now in this case, act of committing robbery, this consideration on part of B what is the consideration of part of B here? For the consideration of part of B is that B must commit a robbery. Okay, this consideration is not a valid consideration, it is unlawful. Okay, it is opposed to public policy as well. We cannot allow crimes. Okay, so this is unlawful consideration, not a valid one. Suits by a third party to contract. Third party means, okay, third party is one which is not a party to the contract. Contract is between A and B, and anyone else is, everyone in this world is third party. Though under the Indian Contract Act, the consideration for an agreement may proceed from a third party, and a third party cannot sue on contract. Only a person who is party to contract can sue it. Okay. Now there's a contract between A and B. Only A can file a case against B, or B can file a case against A. Okay. Now C, D, E, F, etc. These people cannot file a case against B or A. Okay, they are third parties. They do not have any right to file a case against A and B for the performance or non-performance of the contract, because contract is between A and B. Nobody else has any issue with the contract. Example, P who is indebted to Q, P has taken some money from Q, sells his property to R, and R promises to pay off the debt amount to Q. If R fails to pay, then in such situation, Q has no right to sue, as R is a stranger to contract. Okay, R is a stranger to contract. Okay, P has to take some money from, P has taken some money from Q, and P has to pay money back to Q. What P does, P sells his property to R, and R says, okay, I'll pay the money to Q. Okay, now R does not pay the money to Q. Now Q files a case against R, that you pay the money to me. Now Q cannot file case against R because Q is a stranger to contract. The contract is between P and R. There is no contract between R and Q. Contract is only between P and R. So tomorrow, if he does not perform the contract, only P can file a case against R that you pay the money to Q. He is bound to him. He is not bound to Q. So Q has no interest in the contract. Therefore, any suit by the Q against R will fail. However, the aforementioned rule that stranger to a contract cannot sue is known as a doctrine of privity of contract. Privity means private parties to the contract. Is however subject to certain exceptions. In other words, even a stranger to a contract may enforce a claim on the in the following cases. Now these are the cases in which a third party can definitely file a case in the contract. Okay. In case of a trust, a beneficiary can enforce his right under the trust, though he was not a party to the contract between the settler and the trustee. Okay. Okay, A appoints B as a manager of his hotel. A has a hotel, but now he's not keeping well. So what he does, he appoints B as a manager, that you operate this hotel in the benefit of my minor child. Tomorrow, when my child will be major, he'll take over the hotel back from you and he'll run it. But meanwhile, you run it in the benefit of my child. So tomorrow, if B is committing some mismanagement, this child can definitely file a case against P, because this is a case of trust. Okay, he is a trustee, he has to keep the trust. Now he is committing breach of trust, so he can file a case. Okay, in the case of a family settlement, if the terms of settlement are reduced into the writing, the members of family who originally had not been parties to the settlement may enforce the agreement. Okay, A and B. Two brothers. Okay, later, what happens? Son of A files a case against son of B. Now, this is a valid thing because this is a arising out of a family settlement. There was a family settlement between A and B, who were two brothers. They settled the ancestral property by way of a partition into writing. Later on, there were some issues. So, A's son filed a case against B's son, and that is a valid contract, valid case of suing. Though they are third parties, they both are third parties. The original party were A and B. The sons are third parties, but still it is a valid suit. In case of certain marriage contracts, a female member can enforce a provision for marriage expense made on partition of Hindu undivided family. Hindu undivided family says that tomorrow, if a daughter is going to be married, the expenses are going to be paid by the family members. Okay, so tomorrow, the family members say we will not pay the marriage expenses, then this daughter can file a case. Okay, because they are legally bound to do so. In case of assignment of contract, when the benefit under contract has been assigned, the assignee can enforce a contract. Okay, in this case, C can file a case against A directly because A is bound to provide property for mining. He cannot merely give a lease and there is no property at all. Where would he mine the coal? A must provide the property as well. Okay, now because the assignment of benefit, B has assigned the benefits to C. Now C, though originally not a part of contract between A and B, can file a case against A because he is a assignee of the contract. Acknowledgement or estoppel, where the promisor by his conduct acknowledges himself as an agent of third party, it would result into a binding obligations towards the third party. For example, if L gives to M 20,000 rupees to be given to N, and M informs M and that he is holding the money for him, but afterwards M refuses to pay the money and will be entitled to recover the same from the M. Now, when people are behaving in such a manner as they are agents of something, okay, then they are liable to pay back. Okay, now in this case, what happens? L gives money to M. There is a contract between both these parties, L and M. Okay, now L says you take this money and give it to N. Okay, and M informs N. M then calls N and says that I am holding money for you and I'll pay you back. Later on, M refuses to pay the money. Then this person N can file a case against M. Originally, the contract was between L and M, but M behaved in such a manner which resulted into N believing that yes, he will pay the money back to me. Now he is now estopped. Estopped means once you have behaved in a certain manner, now you cannot behave contrary to that. Okay. So when he is acknowledged that he has to make the payment, then he must pay. In case of a covenant running with the land, a person who purchases land with notice that the owner of land is bound by certain duties affecting land. The covenant affecting the land may be enforced by the successor of the seller. Successor of the seller, A sells land to B. A sells the land to B. Now, on A's land, there's a public well, and the general public takes water from this well. Tomorrow B, after getting the land from A, dumps this public well. Okay, he's covering this public well. He says, I'll not let public take water from this well. Now public can file a case against A. Though public is not a party to the contract, public will say that we have been taking water from this well and this well is a public well. He cannot compel us not to take the well, and he must give some way to the well as well within his from his land. Okay, because this is a covenant running with the land. Contracts entered into through an agent. Okay, a principal can enforce a contract entered by his agent where the agent has acted within the scope of his authority in the name of principal. When the officer is doing something on the behalf of his superior, okay, when a employer is doing something on the behalf of his employee, then employer is bound. Okay, then the employer is bound because he is doing as per the job requirements.